Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week I'm outside the Hearsay Lounge, which is near the courthouse in Houston, Texas, and I'm talking about the top 5 hearsay exceptions. You ready? Here we go. Number 5 has to be the excited utterance. So for example, that car just ran the red light. That would be an excited utterance, and that's an exception to hearsay. Number 4 is another personal favorite, and that is the ancient documents exception. I'm sure there's some scholarly literature on why we have the ancient documents exception. I just find it curious that there's an exception for documents merely based on the fact that they're old. Anyway, that's number 4. The number 3 hearsay exception, now we're getting into the really big ones. That's got to be the business records exception. The business records exception is fun because it's always fun to put on a witness to prove up the business records exception, especially when you're just kind of reciting a script and the witness doesn't really have any personal knowledge of how those 8,000 pages of documents were prepared. The number 2 hearsay exception is really the trial lawyer's bread and butter, and that is the witness's own prior inconsistent statement. So, for example, the witness's prior deposition testimony offered to impeach the witness's testimony on the stand. That's one that every trial lawyer is familiar with. Finally, the number 1 hearsay exception, this is a little bit of a misnomer because it's not even really an exception. It's defined by the rule as not hearsay, but we'll call it an exception. It is the admission by party opponent. If the out-of-court statement is by a person who is a party or the representative of a party, then that person's statement is not hearsay and it is admissible. Of course, if it's relevant. So those are my top 5 hearsay exceptions. Did I miss one of your favorites? Let me know. And hey, thanks for watching.